Hey, everybody. Thanks for joining us again on this, I guess, Thanksgiving episode of Art of Law. We have a bit of a Spider-Man theme going on today just to try to make things a little bit interesting. And apparently Mark was just telling me right before we started that there's a new Spider-Man movie coming out that I didn't didn't know
You must
about.
be
So
the only person in the world who doesn't know. Comes out next month. Very sad.
okay, I'm just hoping that Disney doesn't strike down our video when we put it on YouTube. That's what I'm hoping. Um, this episode of liabilities and corporate governance in China, of course, a little bit legal and a little bit drier, but so that's why we're going with the Spider-Man theme today, trying to make it more interesting. A little bit of housekeeping before we get into it. This is, of course, one in a long series now of Art of Law episodes, and everybody who signed up on the Eventbrite page will get a copy of this presentation emailed to them, as well as a link to the YouTube channel where this will be uploaded. And you can find all of our past episodes there. And if you want any of the copies of the PPTs for any previous episodes, just let us know. And also, of course, if you have any questions, just put it in the chat. I'm always looking at the chat. You can send it in the general chat, or you can send it to me directly, and I'll make sure that Mark gets to them at the appropriate time. So for today's episode, Mark, we have kind of 4 parts here. First, we'll talk a little bit about the different roles of executives in a company, how to protect yourself, and then some practical tips that we put together, as well as some case studies to kind of discuss. It's better to learn from other people's mistakes. So we put a couple case studies at the end. So Mark, maybe this question does get asked, especially for those new companies who are planning to enter China, about the roles of the director.
Yeah. So I think here we've got the board of supervisors. I wouldn't normally put them above the directors. I would have thought, even though I guess in Germany you'd have a supervisory board, but the supervisor, it's really unclear what they do. So I think I'd normally put them below. And so I think if you've got a wholly foreign-owned enterprise, you would still have the shareholders meeting and the directors. You can have one, which is an executive director, or you can have 3 people who, can be a board. And people always think that they can, they understand it. And then they always only give you 2 names. I don't know why, but so, you can't have 2. You can have 1, you can have 3, you can have up to 13, but then they always come back with 2. And then I think, in a joint venture, the chairman has to be the legal rep. In a wholly foreign-owned enterprise, the general manager can be the legal rep, and the legal rep's signature can sign, can bind the company. So I guess that's the kind of thing. I guess something which is kind of interesting is a lot of people think that Chinese regulations are often very restrictive, but there's no nationality or residency requirement or a visa for the directors. So it's quite common for a wholly foreign-owned enterprise to have 3 board members, all of whom are, non-Chinese and not living in China.
So you also don't need to actually live in China either.
No, so I don't think you need anybody to be there. And so I think the supervisor, their role is to represent the interests of the investor. So I think that the issue would be, they only came in a bit later into the company law, but if the board of directors and the management conspired against the interests of the investor, the problem was the investor had no standing to bring a case. And so we have the person who's a supervisor. And I just realized a few days ago, I'm a supervisor of a pharmaceutical company. And I only remembered because they sold the business and now I have to resign. And so I suddenly saw my name as one of the people who's resigning. And I kind of forgot. So that really shows you, what does the supervisor do? I was a supervisor there for like 7 years. I never did anything. So I guess, not too much power or responsibility.
Maybe we didn't put this here, but what about board meetings and these types of things, is China pretty much similar to a lot of Western countries, or is it more strict like people might think?
Yeah, you're supposed to have one a year. I think everybody has one a year, especially since you can have like a phone call meeting, or you can have a board resolution by fax, if people still use it as fax. So I think it's not too strict. I'd say joint ventures, they tend to have a few more, but that's not legal. I think, I was a director on a bunch of joint ventures as well. And I think we would have had like 3 joint venture board meetings a year. And I think, perhaps the interesting thing is a lot of people think like a joint venture board, it's like the board of the joint venture, but it's not really. It's kind of like a shareholder meeting, because, let's say you have a board of 4 people, there's 2 from an American company and 2 from the Chinese partner, then they don't really sit down and think what's best for the company. They think more what's best for their companies within it. So it's I think joint ventures, at least the ones who aren't like listed or something, they really don't have a very independent board. It's a bit different.
And the second role here is the legal rep, which I don't know if a lot of other countries have a similar role as a legal rep does here in China. So maybe for those who might not be familiar with this legal rep role, what does that entail, Mark?
Yeah, well, I think everybody's got, like, maybe China's got a bit more, because you have the chops and the seals. Not the animal, the seal, but like a kind of a document. Something you hit on a document. And so the legal rep, WFOE, it's either the chairman or it could be the executive director. So if you've got a board, you can have a chairman, or you can have a general manager. And so the legal rep, will normally convene the board meeting, run the board meeting. He or she can sign. And interestingly enough, even before COVID, so if we had a foreign person, non-resident, who was legal rep, very often they would give their personal chop to somebody, to safeguard or to hold, and they would chop stuff. I don't think the legal rep really signs many documents. There's some tax documents, and then there are sometimes, very important contracts. If it was a big tender, the company might require the person bidding to have the legal rep sign. Or if it's a high-level state-owned enterprise, you might need to get the legal rep signed, because they take these things very seriously. And so I think most people who've got a board, the legal rep has a lot of like reserve power. So if we're talking about a joint venture, and what typically happens is, in most cases, the foreign partner would appoint the general manager, and then the Chinese partner would appoint the chairman, who would be the legal rep. And so it's often important not to combine the roles. So I think, what we would normally do would be, if that's the scenario, we would keep the chairman as boxed in as possible. So the chairman, he or she wouldn't have the right, to make too many decisions. There'd be quite clear wording in the articles about how they could make decisions. And also, if they're not available, then the vice chairperson would take over. So I guess that's the kind of way that it works in China.
Yeah, I think this the role of the legal rep, and we won't spend too much time here, but I think it is important to at least cover it a bit. To me, it just seems like the buck stops here type of role. So, what happens, for example, Mark, if the person who was the legal rep, for example, no longer works with the company, or you might have a bad legal rep who is, detrimental to the company, and you want to change because of the importance of the role, as opposed to, like, let's just say the supervisor, like you were talking about previously. But, especially when they hold chops, which is kind of like a physical, actual object that kind of symbolizes the consent of the company. So, what are some of those special, I guess, cases around that look like?
So I think the chairman, he doesn't normally have to, he or she doesn't have to hold a chop. The signature's enough, so they don't need to have a chop. I think we've had cases, like, one of the special things about legal rep is it's not difficult to change unless they don't want to change. So that's one issue. because the legal rep's name appears in the business license. So directors you can change in a week, just hand in the documents there, SAMR. But the chairman, it takes a bit of time to deal with that. It will take typically 6 weeks. And if you have a recalcitrant, chairperson who doesn't want to leave, it can be difficult. So it's important to get them to sign up early. If they don't want to sign, you can always make it sound like there's a lot of liability. I think there is liability, but it's still pretty rare. I think there are cases at the end where we talk about those special cases, but typically the company will be liable for its actions. The legal rep will normally only be in trouble if something really bad has happened, like a bankruptcy, they want to hold somebody. There's been a big fire. If you've been selling counterfeit drugs or something, I think that's where the legal rep, perhaps first amongst equals, will be in trouble. And then I think, we've also had the case in a joint venture where the Chinese partner just didn't want to agree. So the chairperson, she wanted to leave, and, the employer who was, that person had departed. So they really didn't have an interest to hang around. They were very keen to get out. But in Beijing, they wanted to see a unanimous board resolution for some reason, which I don't think was really legally required, but that's what the Beijing authorities wanted to see. So, I think that person's still the board director, the chairman, even though she left the company like 4 years ago. So, it can be often the case in China. It's hard to push things through. So very often you need everybody to sign off and consent to things. And then, I think if you have, the worst case we had, I think we had this case, we did it on the fraud and management, where we, had a kind of a joint venture where the Chinese partner was a shareholder in the Hong Kong company. The Hong Kong company had a woofie in China, and that person was both general manager, chairman, and was obviously the signatory. And trying to get him out was impossible. If we followed the Articles of Association, it would have been impossible. So we just didn't follow the Articles of Association. We just told everybody he was sacked. And, it was legally perhaps not the best way to do it, but it was the only way to, break the situation. Otherwise, you just would be discussing for him forever.
So with that said, maybe we could talk more about how to protect yourself. And this is obviously coming from the executive's perspective. So we have a couple topics here: diligence, loyalty, fiduciary duties, business judgment, and we'll finish off with some liability insurance. So maybe we could tackle some of these. I mean, these are, I guess, pretty universal, I would say, across. This is not especially specific just to China, but these are kind of the responsibilities of executives across most countries. So a lot of this may sound familiar, but maybe, Mark, we could just have a refresher course for some people. Let's get to the first one: diligence as a director.
Not bad. It's not for supervisors, because I don't think I did anything diligently. But yes, I think they have to act. I mean, even in the woofies or the joint ventures, even though I said it's much like a shareholder meeting, they do have fiduciary duties. I don't think these things are very much going to bite unless you're a public company or a listed company or something. So, they do need to require information to the Board of Supervisors if they're requested. They have to comply with laws, company rules, attend board meetings. It's not too much. I mean, in all those years, I never saw anybody get in trouble for being a director, to tell the truth. I mean, we've got the cases at the end, and we saw some of them, but they were always special cases. So I think this is like a normal fiduciary obligation that you'd have in any legal system.
Yeah, this is very minimum stuff here, but of course required. I guess this one's a little bit more interesting, especially because of the, when things go wrong. But loyalty, Mark.
Yeah, well, loyalty. I mean, if you read it, you kind of think, well, you have to write it down. I mean, it was like, you can't accept bribes or illegal. You can't miss it. You can't steal the company's money. You can't compete with the company. You can't disclose company secret. So I think none of this stuff, if you were showing this to a director and, he or she took, issue with it, you kind of wonder, where their loyalties lie. So again, I think it's kind of common sense. I don't think it's a particularly high bar to meet. Yeah, there's nothing particularly sophisticated or complicated. It's pretty easy stuff to comply with.
Yeah. But a lot of cases do stem from this, though. Fiduciary duty, and especially what we have here are three different categories under the fiduciary duty. First, and Mark, you can explain more in more detail, but first, duty to the company, the shareholders, of course, but also to third parties, and the third one in regards to knowing your legal responsibilities under regulations.
Yeah, so I would have guessed until like a few days earlier this month, this week, yeah, normally like the duties of the company, the shareholders, it's not going to be particularly complex. It will be if we've got a joint venture that is in trouble and there's a dispute, people will start flinging this around and attacking people for that. But I think where you've actually seen people a bit nervous is duties to third parties, and this could be creditors. So if you've got a bankruptcy and you were the legal rep and you were a foreigner, you wouldn't want to be hanging around. You would like to be outside of jurisdiction because you don't know, what the creditors will do. You definitely don't know what the employees will do. It depends. If you've got money to pay them, it'll be okay. If you don't have money to pay them, who knows who else? I think that's the main third parties are the creditors and the employees. And that's, I don't think it's in a normal liquidation. Like a liquidation normally is everyone gets paid. So unlikely that people go crazy. But if it's a bankruptcy, which happens rarely with wholly foreign owned or joint ventures, then it might be, a little bit more, risky to be a director, much less the legal rep. And then I think, I don't know if it's really special laws and regulations, but these are the things where people could get in trouble. So environmental protection has been a big thing now for a few years. So, the authorities really do clamp down on it. So, maybe 20 years ago, you could do stuff and get away with it. Now, it's a big deal if you, just, pour effluent into the river or something. Production safety, I think that's mostly if there's, a health and safety issue that resulted in death or serious injury or something like that. I don't think it's like a minor transgression or something technical. It has to be something like that. Like, often like fire safety or something like that. If there's something like that. And then, tax and customs, again, we did have a client, but I haven't heard from them again for a while. But they were involved. They were involved in it before they became our client. But they were involved in mass smuggling and tax evasion. And their legal rep for China, went to jail for 15 years, recently. So I think, those kind of, big breaches, not like technical or small breaches. Like I said, most breaches are the company's obligation, but it's only if you're really doing something beyond the pale, then the people controlling the company are in trouble.
And in the previous, I think a couple episodes ago, Mark, we did one on data protection. I know this is not necessarily fiduciary duty for a director, but these new laws are also requiring new roles to be formed and putting obligations on these new roles, such as like the data protection officer and these types of things. Would you kind of slot? Do you think maybe we should update this slide and slot some of that information in here too?
No, I don't think so. I think, like maybe if it was like a massive breach, if you took 10 million people's data and illegally sent it overseas and it was all sensitive, then you might be in trouble. It might be there. But I don't think the data protection officer, it seems that the PIPL, the privacy law in China, it's modeled on the GDPR. And, the GDPR also has that kind of data protection officer. And that person is more just somebody who understands it. If there's an issue, they can talk about it and they can get answers. It doesn't seem that likely that they'll be liable for things to the same extent. Probably if there is a big liability issue, again, it will be, the bosses rather than the data protection officer.
Yeah. And business judgment, which is quite universal, but maybe just a quick recap of business judgment rule, Mark.
Yeah, I think I guess the main thing is, if you can show that you are doing the best outcome for the company and the care, and so I think how this protects people is if you don't have knowledge of the thing, if you didn't sign off, if you were in the minority uh, in the board meeting, then you shouldn't be the person being held responsible, but you do have the burden of proof. So I think until recently, I always had thought that if you were a director but you didn't have knowledge of it, you'd be okay. And then there was a case a few days ago which broke, I think it was Kangjiu Pharmaceutical, where all these non-executive directors who are mostly academics are facing hundreds of millions of renminbi in liability, and they only get paid 20,000 renminbi a year because the company seems to have falsified its sales records. And so this has led in the last few days to almost every non-executive director trying to resign. So, so it's kind of interesting, until a few days ago, I didn't actually think that you could get in trouble if because I thought it was actually last week, one of the partners in China asked me if I could look around for somebody in the luxury business, a Chinese company doing an IPO was looking for somebody to act as a non-executive director. It's going to be a bit harder to find somebody now to take that role on, because I also don't know this D&O insurance. I guess it comes up later. I don't know how reliable it is in China, how it works in China. It's a bit difficult to say.
That's interesting. So what do you mean that the burden of proof is actually on the director, that they would have to they have to proactively show that what they did was in their business judgment what was best for the company? Is that what you mean?
Yeah, and was reasonable, they acted in good faith. I mean, so it's not like you have to, it's always harder to prove those things. It's you normally would think the burden of proof is on the other side to show that you did this, but proving that you're innocent is actually a bit difficult. So that is perhaps a nuance which is unhelpful for directors.
We cover some of this in the tips section, so we'll get to that in a little bit. I threw this slide in here, Mark, not just specifically because it's safety, health, and environment, but I think it gets to the point where that directors should have some knowledge of their duties under law, and this, of course, being one example of that. But maybe, like you said, that directors do have some responsibilities under the regulations for certain types of events, such as work health and safety.
I think they'd only get in trouble if there was a big event. If there's a lot of people injured or people dead, then that's the big issue. I think otherwise, these kind of issues will have to be dealt with at the company level. So so it's important. I mean, also, if you are a director, you should take these things seriously. But I don't want to make people feel overly nervous about these things.
Yeah. So that brings us to the liability insurance, and it is, like you said, Mark. This is kind of it is an insurance, but if you're doing something willfully wrong, then the insurance is probably not going to cover that, just like any other type of insurance. So, but maybe you could just quickly just go over how this liability insurance works in theory, and then also your thoughts on how useful it might actually be in practice.
Yeah, I don't know. So I mean, I think it's pretty clear. I mean, so the liability insurance would normally only cover like legal expenses and things like that. But if they confiscate your illegal income, the insurance will not reimburse you for your illegal income or things like that. I think the bigger issue is there are some Chinese insurance companies that provide this D&O insurance. I was a director in this joint venture, and it was in Liaoning province, and it wasn't that long ago, maybe 10 years ago. And at the factory, we had a small fire. It wasn't a big fire, but it was a small fire. And they had insurance throughout the life of the joint venture for like probably was 10 years before this fire. And it was like 10 years ago. And so during the board meeting, the general manager explained that the insurance company had rejected the claim on the basis that the fire was an accident. And this was I just was trying to work out, like, well, when would they feel they would pay? I mean, like, if it's an accident, you think that's when you would pay. I mean, like, if somebody did it on purpose, you think, well, yeah, I can understand, you might argue there. So I've always been a bit concerned about insurance. The Chinese insurance can often be, the premiums can be very cheap, but I've always wondered what kind of coverage you get. So that's the issue, I guess.
And I've heard you mention this point before, but maybe it's worth repeating that some of the insurance definitely, if it doesn't cover accidental fire, then it's definitely not going to, like you said, I mean, like you were like you were implying, it's not going to cover intentional fires. So like, all of these intentionally negligent or criminal acts by directors, I mean, your insurance company is just not going to pay you for that stuff. So, it is important to think about exactly what type of coverage what acts are you actually looking for coverage for. But I understand that, a lot of international companies might feel a little bit safer with the insurance rather than without. But this is just our Mark's thoughts and our thoughts on this. And all that said, we'll actually get to some practical tips, and we kind of mentioned this a little, some of them a little bit before, but maybe first, Mark, we could just start with some of the red flags that you've seen throughout the years. I know you've written a lot of it. We're actually moving offices, so I put away my book. But in the book, of course, you've mentioned a lot of these different red flags that you've seen throughout the years. So maybe it's worth staying on this slide for a little bit and just tell us, about them.
Yeah, so I think the red flags, but this might be more about not just directors, but also management. So I think maybe this is what we would look for, especially in COVID now that we've seen. I think we had a webinar with Mike Brown. He talked a bit about uncovering fraud when in a world where head office and audit is not very easy to do. So I think these red flags are mostly about directors or officers not doing things properly. So I think where it's rare that people don't see red flags. So it often starts with excessive gifts, very big entertainment expenses, abuse of petty cash. And then, I think the more serious ones would be like where they use false accounting, the internal controls don't work. And then, payments to third parties, commission payments, sponsorship's more of a pharmaceutical type of thing. And then if they have delegation trips or site visits, unrelated travel. And then, I think we've seen a lot this year. Maybe people were doing badly economically, but I think we saw more this year than ever before. A lot of complaints about procurement kickbacks, like whistleblowers from within the company, or also suppliers, reaching out to headquarters and saying that, often the general manager. So I don't think it's the directors very often because they're not involved enough in the procurement or the purchasing functions. So these are more issues for the general manager. And then, very often if you've got somebody who, is not just a opportunistic criminal who just wants to steal a bit of money, as things go along, but people who really have built like a bit of a network, they'll often have agents or distributors or consultants. We had one case where the HR, head of a big, foreign invested company had a large, multi-million renminbi consulting agreement with a company owned by his mother. So, that wasn't disclosed. And obviously she had nothing to do with HR. So I think, these kind of things are things that we see misbehavior, but not that often, at the board level, more the management level.
Yeah. Well, if some of these red flags are present, then what do you think should be the next step? Because do you in your experience, do you think that if you see one red flag, that there are other red flags probably underneath the surface that you haven't discovered yet, or what are your thoughts on that?
Well, I mean, firstly, let's say, if we're talking about a headquarters perspective, how do people find out about it? It's normally a anonymous, reach out via an email or something like that. And so I think, firstly, one can't just assume that it's true. Although I must admit, I always think where there's smoke, there's probably fire. So most cases, and so I think it depends how large the company is, but most companies would seek to engage in a dialogue with the whistleblower. Some people have special sites where you can upload documents. We've been involved in a number of them, and one of them, the person kept on writing cryptic long emails. It seemed very clear that it was a long-term employee, but I must say they did something which I hadn't seen before, and they referred to themselves as nobody. And this made it quite exciting. It was like a horror movie, like, I'm nobody, and just all the emails were signed nobody. So that was kind of interesting. And so I think we all know who nobody is, but because nobody is not keen to go on a call, because I think nobody thinks that we know their voice. So it's interesting. So I think it's difficult to prove things, and so I think people have to follow it up. And in some cases, the whistleblower may not just reach out to the headquarters of the investor, but in another case we did earlier this year, the whistleblower also reached out to some of the American clients or customers of the company, and of course, because they have those strict compliance regulations, that became another big headache, because then they wanted information and they wanted to see that we were following up. So I think you can't really not do it. And now with, it seems clear the trend is to have a compliant supply chain. So if you get a whistleblower who says that there's kickbacks in the system, I think you have to take action. If they say that they're, buying, materials from somewhere dodgy, you probably have to look into that. So I think you can't just ignore those kind of claims. And in most cases, there is something happening. Somebody is making these kind of statements.
Yeah, I guess this is kind of a case-by-case basis, and it is a little bit, it's a tricky one to do. But
well, you also can't destroy somebody's reputation just on the basis of an anonymous tip-off, but you have to check into it. That's the
So we have here some, so their animation. Yes, okay, some third parties, because we talked about payments to third parties and all of these other types of things. We just list here various different third parties that you might have seen. And Mark, I don't know, do you have any stories that where you've seen some of these obviously payments to consultants and maybe distributors from a procurement standpoint? How creative does it get, I guess is what I'm trying to ask. Or is it pretty apparent once you start digging into the books?
Yeah, so I think, so consultants and distributors, that's normally somebody trying to steal money from the company. So they might be the distributor, or they may be the consultant, or they may own, the property. So I think that's one type. Then with suppliers, that's mostly people looking for a kickback, suppliers or vendors, that would be a kickback. Government authorities, I don't know. You have to be pretty brave to do that. At least nobody's come to us, and I haven't seen that accusation for many, many, many years. So, is it happening? I don't know. I think, those Chinese government authorities, I think they've got a reputation for being very, clean. So it would be a big surprise, to do that. So, that one I would be querying if that's really something that happens very often.
And you mentioned information and the right to access information. Maybe you can just briefly go over what information do you have access to, and which information's, and we put it here in the black, but which information should kind of be at the top of the list for a director to kind of keep a closer eye on than others.
I think here, I think it's more about whether the director, it depends what kind of company. If we're talking about a listed company, it's different. There's much more oversight, et cetera,
Yeah.
et cetera. They have a different thing. If we're talking about more what we do, like a wholly foreign owned enterprise or a joint venture, yeah, on a wholly foreign owned enterprise, I don't think this would ever come up. I think the directors would get whatever information they want unless there's something seriously wrong. And in a joint venture, the problem would be if the management, if there's a disconnect, and let's say the typical case is the Chinese local management doesn't want to give the foreign company access to information. I think the problem is, not only do you have this under the law, but joint venture contracts will have pages about what access you get, and you can send an auditor in. But in reality, if they don't let you through the front door, you're not going to get the information. And so I think, it's difficult, and going to courts is, you can do it, but even if the court says, yeah, give me information, trying to enforce it's very difficult. So I think, these are things where we have to be careful. If we're talking about a joint venture dispute, we have to be realistic as to what rights we can actually enforce, rather than just, knowing that they exist.
Yeah. So before we move on to the case studies, Mark, I have two questions here. The first is, in your opinion, what do you think is the biggest difference in corporate governance in China versus the West?
I don't know. I think I don't know if it is different. I think it's probably. I guess the difficulty for people would be, most people don't. Even if you've got a company in Brazil and you're an American, it's not your home turf. So I think, the kind of companies we see, I think Chinese directors, except for those non-executive directors in that Canjin pharmaceutical company, they probably know what's expected. They kind of can sense what the requirements are. I think perhaps the difficulty is if you're a director in a Chinese joint venture, you're quite removed. Even before COVID, you might go once a year, twice a year. There might be cultural barriers. You might not be able to read all the documents, all those kind of things. So I don't think the issues will be different in the West. It's probably just that the directors, especially those foreign directors, they may be less well equipped to really do their job in the right way. It might be considered more a title than an actual role, like, I'm the Asia Pac strategy guy, so I sit on 4 different joint ventures in China, but I don't spend even 1 hour a week on any of them. I think that's the problem. It's not really the dynamic of the Chinese market. Obviously, it's quicker and there's a lot happening, I guess. But I think that's the big difference, is people often don't take it as seriously as they should.
Yeah, I think that's a great point about the maintaining that structure, especially during COVID, is probably the biggest challenge right now. And I have one other question here, and this might be a little bit. I don't know how much knowledge you have on this topic, but I figure I'd just throw it out there. Would the liabilities be the same for a trustee company in China? Now, I don't know. I would assume that directors are directors under the law, regardless of the type. But I don't know if you have any thoughts.
As far as I know, there might be some new changes recently, but there's not really a trust law like we have.
Yeah.
So normally what you'd have is more like a VIE model, or somebody who is on paper but not, which I guess is a trust model, but and the trust model, it's a bit different in the West. It's hard to explain to Chinese, perhaps people who are not familiar with trust structures, because it's also hard to explain to Westerners, because I think the trust thing really resolves on trust, and it's difficult to get your mind around it. If a trustee is aberrant or is a bad player, so hard to see how you take action against them. So I think firstly, I don't think China has that kind of system yet. And when we talk about trust companies in China, they're kind of like shadow type banking institutions who the Chinese authorities are trying to clean up. So I think it's a bit different than in the West on that.
Yeah, especially that previous example you gave where that person was the director, the chairman, the legal rep, all of those things, and it's just so difficult to get rid of. If it was a trust structure, then it's probably even going to be
I don't
tougher.
think they have, I don't think they have those kind of trust structures in China. I don't think it's the same as in the West where you have
Yeah,
set beneficiaries.
yeah. I was just saying, if you even tried to mimic something like that here, probably would be much tougher to resolve if that trustee just does something that is not in the benefit of the beneficiaries. But all right, so we just have a little bit of time left, but Mark, maybe we better spend this time to talk about some of these case studies here, because I always think these are very interesting, and it's always good to learn from the mistakes of others.
Yeah.
And number one here is Farine, and I was actually in China during this time when this happened. So this was pretty exciting for me to watch unfold. But maybe Mark, you can just explain what happened in this case.
Yeah, I wasn't involved in it. I went to the Farine shop, and I think the first one was at Ferguson Lane, and the guy was called Fonk, and he had that restaurant at Ferguson Lane as well. And so I think, I have imperfect, understanding, but it always seemed a bit weird. There was these allegations by people that he was using expired flour, which, you wouldn't really think would be something that would start getting, the police mobilized. We've had many worse things happen, and the police didn't seem to be too excited about it. I think there were also photos of rats, running around, but, again, Shanghai's got a lot of rats. But I think, the tragedy was, I understand, was that Frank was in France and he stayed there, perhaps very wisely, but he had some new French employee who was almost just fresh off the boat. And I think that guy was put in jail. And this is a long time ago. I assume he's out, but I think a couple of years ago, he was still in jail for this thing. So, it kind of can show you that it's a very unexpected thing. If somebody had came to me and said, "Oh, look, we've got an employee, he's got these whistleblowing allegations that we've been using expired flour in our baguettes," I would have thought, okay, well, that's not a stop using expired flour. I wouldn't have expected this kind of thing. So it kind of can show you that things can escalate, but I think it's really the 1 in 1,000 or 1 in 10,000 case. But yeah, so I don't know, Sean, do you have thoughts on it?
I just thought the interesting part about this is, it's not that interesting, but the whistleblower was an employee, right? So
I think an ex-employee. I think it was somebody who also set up a French bakery. So, yeah.
But actually, I think, one of the things that, I've heard you talk about before is just disgruntled employees is kind of one of the sources of, problems. And it's not, it's probably because they might know your secrets or, whatever it is, but they know your operations and they know where to hit you if they really wanted to hurt you. So, we were talking before about the employee whistleblowers. Well, this is one of those instances where maybe the ex-employee or disgruntled employee just doesn't want to message headquarters and rather just take it out publicly.
Headquarters is Frank. Frank was there. He was the owner, so it wasn't like there was some guy living in Paris. Yeah. So I think with the whistleblowers, I think there's two types. There's, like, most employees want the company to do well, and so a lot of those whistleblowers are motivated because they think it's bad what's happening. The general managers like sucking money out or bringing in useless people or hiring his mistress or doing these things. Most people don't like it, and that's the interest of the company. But the other type of whistleblowers, like perhaps this person, disgruntled employee, But yeah, perhaps the subset of the disgruntled employee who's very dangerous and is a total pain is the corrupt employee that you kick out, typically a general manager. And, unfortunately, because it's so hard to get rid of the buggers, you normally, even, enter into a termination agreement. You often pay them some money to go away. And then those guys will go to the tax office and they will, disclose all the things because they know, because they did it. And so that is, that makes it difficult. And it's not a good explanation to say, well, that guy was a criminal. I mean, could put him at risk, but typically the tax office just want the tax revenue. And so that is where a whistleblower can be very strange. So often once you even get rid of the person through the door, the person can still come back and bite you, so.
Yeah, that's true. And number two is the Sanlu milk scandal. I think a lot of people who have been around China probably knows this case very well. This is, this is definitely a much more serious case than the previous example. But Mark, like you said, big events, right? So maybe you could just describe this big event for those who might be familiar, just a refresher for those who
I think the thing is, you're a bit lazy, Sean. You could have. There's been many scandals since. This is like just before the Olympics, so people were upset about it breaking then. I think, the thing was, I think the people were buying, the milk company was buying the milk for the infant formula and milk generally. And sometimes people do stuff that you just can't understand. And so melamine, I believe it's a hardening substance that you put in furniture. But if you put it in milk, it makes it appear that the protein content is higher. So, so these farmers were buying melamine, which I think would lead to like liver and kidney failure. And, they were, putting it into the milk they were selling to Sanlu. And then that was contaminated milk powder. And, obviously, nobody really likes companies that sell, contaminated milk powder to children or infants, even worse than children. And so that was a massive scandal. And, the problem was, I think, I don't want to defend the people selling contaminated milk, but it's something which somebody once told me, you would never have looked for it because nobody would have thought to look for melamine, because it's not something that you'd expect. You might look for salmonella, you might look for some other things in that, but nobody would have thought anybody would have introduced into the supply chain a furniture thing just to increase the protein. So it was tough. And people had, not tough, but it's bad. And obviously the children are the biggest victims, but also those people, I can understand how that happened. I think we've seen other cases with, a few years ago, there was those dodgy vaccinations and things like that. So, this will be the issue. So if you're in a company which is selling pharmaceuticals, food and things like that, chemicals, if you're, I think all these people, the directors, will have to make sure that their supply chain is, safe and secure.
Yeah. I mean, obviously this case is so black and white, but I mean, if we could just muddy it up and change some of the, just get a little bit hypothetical. The takeaway for me would be that if you were a director, you wanted to protect yourself from, for example, the supply chain, because you don't know what's happening in the supply chain. Or if it comes up in the, board meeting or directors meeting, then you would need to, like we talked about earlier, the proof of burden is on you to show that you've, made your best judgment on a decision. So Mark, in that case, would it be like, if you don't know, what's happening, is one of the tips here to just make sure that everything is in writing if you don't agree with a supply chain decision, for example, or or maybe conducting due diligence? Is this how a director would probably try to build up some of that case of I didn't know, or I've made my opinion clear type of defense?
Well, I think here, at least on this timeline, it says that the problem was reported. The management decided to not to continue selling the contaminated milk. So that, made them bad actors. But I think, this is a long time ago. I think now we're in a stage where it's probably not enough not to know, it's probably now you got to know, So,
Yeah.
and, I don't know what the technology was like back then, but nowadays people do have these handheld spectrography or spectrometry type devices. And I think people have to check things. And, I think there would be a burden of proof to show, melamine, you couldn't check it. It was something which is too difficult to check. But I think you can't get away with I don't know anymore. I think if you didn't agree with it, you'd want to put that in writing. You might want to become a whistleblower. You might want to go to the authorities. That'll be the tough things. You get, and I think back then one of the issues was, I don't know, maybe the local government didn't want them saying it either because the Olympics was just around the corner, and they probably didn't want to scandal one of their local champions. So it's not easy to be in these situations. It's easy to act like, oh yeah, I would just do this, but if you're the one person, saying we got to go public, I don't know how easy that is. It could be difficult.
Well, this case is a little bit more interesting. I think just from a general, what can we learn case study, transpacific trading. So for those not familiar, the CEO of Transpacific was detained by customs at the Pudong airport on his when he was flying back home. It was resulting from a dispute with a customer. And I think this is kind of, this is pretty typical, I would say, just having a dispute with the customer. So I know that you briefly touched on it, Mark, before about, if you're in a bankruptcy, for example, and you have those fiduciary duties to third parties, like we talked about the creditors and your customers, this, I guess, kind of goes to the heart of that. So, Mark, is this something that, how does one, I guess, what does one learn from this case, and, what tips can we kind of extract from it?
Well, I think, this case, I didn't know of this case, until you showed it. But I mean, there's like hundreds of these cases, like really literally hundreds, where, there's a commercial dispute, and then the customs, or the immigration, I guess, not customs, immigration will just hold the passport, and they just hold it. You're not put in prison or anything, but you just can't leave the country until you agree. And that obviously gives the Chinese, counterpart strong leverage. So it's difficult, and he didn't. I'm assuming this guy didn't have a company in China, so it was really a cross-border dispute. Yeah. And he was kind of held hostage. I don't know if other countries do this, but it's a very regular thing, which is kind of a bit outrageous. Actually, it's a bit outrageous. But we had it lots of times. I mean, we've had it quite often, and so we would often tell people not to come, or they go to Hong Kong or something like that. But because it's normally the local authorities, it's not easy to get if you've got a company in Changzhou, it's not going to be easy at the Shanghai authorities to just detain somebody for you. But if you've got strong local connections, you can normally do it.
Yeah, and this is just another case that's pretty similar. There was some disputes, it seems, but maybe it was with the police charged this CEO with writing bad checks to a SOE. And of course, the CEO denies that and says it was due to something else. But these are just the types of, I guess, scenarios where you don't want to get into.
We have to be careful. I mean, I don't know. I've never seen.
Yeah, exactly. Before. I mean, it's all he said.
Maybe he did do this. It's right. It's like, I think this one I haven't seen much of. I think I think my experience with the police that we've had is it's not easy to get them to do things. They don't want to just get involved in everything. There's a level. If it's an embezzlement or something, it's not normally that. It's not like the TV shows, that they want to bust down the door and do everything. So, I think, there's a state-owned entity, but they really make it right. So I don't know. I would say it would be something that I think one would look at. I think the one before, that's quite common. This one, I think you couldn't say whether it was legitimate or not legitimate.
Yeah, exactly. And we don't need to go through all of these, but we're basically out of time, Mark. But I just want to I put some key takeaways here for everybody who will get a copy of this presentation. I guess the lesson, I mean, the big takeaway for me, Mark, is the first one, right? Like if you don't agree with something and you're not exactly sure, then you should probably try to at least protect yourself, because some of these case studies is just that was obviously lacking, or they were even complicit with it. So follow some of these tips, and hopefully it will help you in the future. Any last words, Mark?
I think the only thing I'd say is in the last year, I think I would have been a director in any bloody thing, until about a year ago. I just thought, it's an okay company. I think things have changed, and this thing now last week with the non-executive directors, or this week, facing hundreds of millions in claims. I think you can't just take it lackadaisical approach. I think it may well be, don't be a director unless you're really involved in the business. Don't do it just because it looks good on the resume, or it looks nice. I think if you're not really actually connected to the business and you don't kind of know what's happening, probably better not to be a director.
Yeah, that's a good point. All right, everybody, thank you so much for joining this episode. Like I said, everyone will get a copy and also a link to the upload on YouTube. Thanks a lot, Mark.
Thanks, Sean.